For those that don't know me, my name's Brenton Pike, the Registrar-General. Joining me today to present is Steve Wilden, Director of Operations and the lead on National Electronic Conveyancing, and Cristina Florea. She's one of our business specialists dealing with some of the policy changes. Electronic conveyancing. Some of us have been on this journey for 10 years, and I reckon I was standing up here 10 years ago talking about the same thing. It's coming, it's coming, it's coming. We're here today to tell you it is coming. The government have given us money, and we're due to play our role in electronic conveyancing by 2015. So this is the first of many information sessions we'll have to keep you informed. There's a number of policy changes that will need to be implemented. Today we'll launch one of them, but we'll also give you the context of what's happening on a national stage. I'll give you an overview of what's happening locally, and then Cristina will release in detail the first policy, which is the verification of identity. What we tend to do after those three phases is give you time to answer questions. So Steve will present on the national context, we'll take questions from the floor, I'll then present on what's happening in South Australia and what our policy positions will be. We'll take questions, and then Cristina will get into the detail around the first policy that is released for consultation, with a target date of implementation being the 1st of July. So without further ado, I'll hand over to Steve to talk about the national overview.
Thanks, Brenton. As Brenton highlighted, I'm just going to talk a little bit about what's happening nationally, just to set the context, I guess, of the work that's going on around the country in electronic conveyancing. As Brenton said, we've been talking about electronic conveyancing for something like about 13 or 14 years. The first committee that was ever established was back in 1999 to look at this. And as Brenton said, there's been a lot of engagement with industry. It's been some years since we've really talked seriously about this, but we are over the talking. This is actually happening. We are funded, government has committed to it, and we need to be working towards implementing electronic conveyancing. What is electronic conveyancing? To some people, it is just a system. To us, it's more than that. It involves and includes a legal framework, which gives the rigour and control around the use of the system. It includes some new business practices, and also include the business model. It's important we have a sustainable business model. If we're all going to commit, change the way we operate, both from a land registry's perspective, from a revenue office perspective, and from an industry perspective, we need to have confidence that the business model will be successful. So I'm just going to talk about these four aspects, and then I'm going to talk a little bit more about the time frames, and then we'll hand over to Brent to talk about what it means for South Australia. This is a pictorial view of the legal framework. In essence, this is a COAG project. It's one of the 28 partnership agreement projects that were signed off by the states. The states have all committed through an intergovernmental agreement which commits the states, binds the states to implement electronic conveyancing. And as a result of that, there's been some national law put in place. And the national law pretty much allows for the establishment of an electronic lodgement network operator, which is what we call an ELNO. So you'll hear that phrase from time to time. An ELNO is an electronic lodgement network operator. And in this instance, the first electronic lodgement network operator will be a company called NEC. So I'll talk a bit about NEC today and what their role is, but that is a company that you're going to hear a lot more about over the next 12–18 months. The intergovernment agreement sets the governance for development, implementation and management of the regulatory framework. It also establishes ARNEC, the Australian Registrars Electronic Conveyancing National Council. Now, ARNEC is an important role here because ARNEC is actually going to be the regulator and sets up the legal framework and controls for electronic conveyancing. ARNEC comprises all the registrars from Australia. So it's a national body, and it's a commitment from all the registrars to introduce consistent business practices across Australia. So there will be some change in our business practices to align with other jurisdictions, and other jurisdictions, again, will be making changes to align to our business practices. What's important is all new business practices that are put in place will be consistent, and that's where we'll be talking about VOI and client authorisations, and Brenton will be talking about them in more detail, and these will be consistent practices across the country. The Electronic Conveyancing National Law is the law that facilitates the establishment of the electronic lodgement network operator. It puts in place and provides for establishment of what we call operating requirements. Now, these are the requirements that the ELNO will need to comply with, and they're very, very stringent compliance requirements. They'll also put in place the participation rules. And the participation rules are the requirements that a subscriber or a conveyancer or solicitor will need to comply with. And I'll talk a little bit more in detail on these in a minute. It also allows for the effect of using a client authorisation and for the application of a digital signature instead of a wet signature as we know it today. And most importantly, it allows for the registrars to check compliance, to ensure that subscribers are complying correctly and to ensure that the LNO is meeting its requirements. So there's quite a stringent amount of governance and rigour set around the Electronic Conveyancing national law. The law itself is an applied law scheme. It was passed in New South Wales in November 2012. Other jurisdictions are in the process of enacting it at the moment. Victoria's recently had approval. Northern Territory's had approval. We're in the process of developing a cabinet submission. It's been to the attorney once. It'll be going back to the attorney shortly, and we will be expecting approval from cabinet to introduce this into Parliament in the next month or so. So we will have our national law, hopefully, this in the next few months. So I mentioned the model operating requirements. These are a set of common requirements determined by the registrars, or NEC as a body, and they set out the requirements that an LNO must comply with. So this is about who can be an LNO, and it's the eligibility criteria and the general business operations they need to follow, such as they must be a corporation, they must have an ABN, they must have appropriate insurance, and they must operate under best practice governance and things like that. So all these requirements are set out in there. We also set out the system functionality, what they must deliver, including things like electronic settlement, lodgement, providing advice back to clients on the lodgement and registration and settlement. It also includes the security. A major aspect of the requirements are ensuring that the proper security is in place to give industry confidence to operate in electronic conveyancing. Associated with that is their approach to dealing with risk management, their risk assessment process, and also making sure they have a proper business continuity, disaster recovery and change management programs in place. Now, it's important that people understand it's not a case of just someone saying, yes, I have all these things. What we actually do is have compliance examinations. So they're required to meet certain certifications, and they're also required to use independent certifiers to assure us that they have the right controls in place to operate an electronic conveyancing network. And that's all about giving us confidence and giving industry confidence that this is going to be successful. The model participation rules are a similar set of rules, but they're set around making sure that subscribers have confidence in the system. And that covers things like who can be a subscriber, such as a conveyancer or solicitor in South Australia, must comply with jurisdictional laws. It also puts in place some of the new business practices we've talked about, client authorisation, verification of identity, which Cristina is going to talk about, our policy today, and also the instrument certifications that are required when you apply digital signature, the confidentiality that a subscriber must use in using the system, and also the security and integrity a subscriber must apply when they're using the system. So all these aspects are covered under the legal framework to give confidence in the system itself. We also need to have confidence in the business model. Now, the National Electronic Conveyancing Development Limited, NECDL, as I referred to earlier, has been established to develop and operate the electronic conveyancing system. It's a corporation limited by shares and is funded by government and industry. It's implementing what is called the Property Exchange Australia, or PEXA as we know it, and PEXA will provide for the preparation and lodgement of instruments. It will provide for electronic settlement of transactions, disbursement of payments to all parties, and notification of settlement and lodgement back to subscribers. This is a pictorial model of how electronic conveyancing will operate. You can see PEXA down the centre. On the right-hand side, you can see that it will be connected to a range of land registries and revenue offices, RO1s, LR1s. These represents all the land registries across Australia. At the top, you'll see that's connected to what we call a financial settlement manager. That's the FSM. And then connected to that also is the Reserve Bank of Australia. And that'll control the electronic settlement process. And then to the left, as you look at the screen, that represents all the users of the system. Users will be able to use the system by browser interface, or they'll also be able to access the system via using their conveyancing packages, because Nectar will be out talking to the operators of the conveyancing packages and ensuring that those conveyancing packages can interface with the system. So it'll be a fairly seamless process over time for industry in terms of using the system itself. We have a video later, which is a promotional video that's been put out by PEXA. So we'll show that at the end of the session, and that'll walk you through how PEXA intends to actually run the system. So that'll give you a bit more of a context as to how it's going to operate. But bear in mind, it is a promotional video. So what does that mean in terms of time frames? PEXA Release 1 will be up and running in June this year. It'll be operating in Victoria, and it will only be dealing with discharge of mortgages and mortgages. So it's really be set up around refinancing. They'll be followed by New South Wales in July, and then it's expected by November this year that Queensland and Western Australia will also be on board. They're targeting the 4 major financial institutions at this point in time, and they've also made commitments, and they've also made contribution to the corporation. So there is very likelihood that this is going to be a significant success over the next few months. We understand that Victoria is already going through testing at the moment. So as Brenton said, we've been talking about it, now it's coming. And Release 2, which is really what we would call electronic conveyancing, which involves electronic settlement, is targeted for mid-next year. So that's the time frame. And at that point in time, they'd be looking to engage all land registries, all financial institutions, and obviously conveyancers and practitioners. So they're the time frames. So what does it mean for us? Brenton mentioned that we've been funded by the state government in the 2012-13 budget. Our aim is to prepare industry and prepare our business for operation, and we are actually looking to align our participation with the implementation of our new system, the South Australian Integrated Land Information System. Now that's scheduled to go live in 14-15, and we'll be making sure that that system, when it comes on board, is ready to participate in electronic conveyancing. We haven't decided as yet the actual time frame for us introducing it, and a lot of that will depend on the successes as we sit back and watch the other jurisdictions over the next 6 to 12 months. We're actually in a good position to learn, I guess, of all the successes they have and any particular failings they have or any issues that arise out of it. So that, quite briefly, is what's happening nationally and what it means for South Australia. So I'll take any questions on that component.
I'd just like to mention on behalf of AIC that when you talked about the platforms being ready to go on, we're in negotiations at the moment for CATS to be participating in this as well, and we're a fair way down the track to completing those negotiations. So those of you that do use the CATS system, you can be assured that that will be ready at the same time that South Australia will be ready, and possibly even before that. So we'll be testing it before then.
Thanks, Glenys. Yeah, it's worth noting that Nectar is putting a substantial amount of time into ensuring, I guess, that the experience for the subscriber is very seamless. So they'll be talking to all the major users of packages or developers of packages over the next 12 months and making sure that when people do come on board, particularly for Release 2, that you'll be able to basically use your existing package and access the PEXA system.
Thanks, Steve. Those documents are extremely important. One sets a context from a systems point of view and allows you as users to have the confidence in the system that it's safe, secure and it's fully auditable. So that's your model operating requirements. That gives you the confidence that you can use it, knowing that it's fully underpinned by safe, secure and auditable system. The MPR is more relevant to you as subscribers. So I do encourage you to get on either the ARNIC website or you can go through the Land Services website, and both those documents, the model operating requirements and the model participation rules, are available for you to view and become familiar with. So if you're into the detail, by all means get on there and have a look. I'd encourage you more particularly to look at the model participation rules, because they are the rules for subscribers, i.e. conveyancers, solicitors, financial institutions that intend to use the system. So, and there's been a lot of work, as Steve mentioned, in preparing those documents. So what does it mean to you as participants within South Australia? I guess we're fortunate, as Steve mentioned, because we've got a bit of lead time before we engage and implement electronic conveyancing. So that gave us some time to take stock, sit back and position on how best we want to introduce electronic conveyancing into South Australia. So the first thing I want to touch on is the alignment between electronic and paper. So from my perspective, there'll be no policy difference between lodging either through electronic conveyancing or if you continue to work in the paper world. And so by that, there will be one set of policies and one set of requirements that will be universal to both mediums. And I think that's a position of strength for us. Other states don't have the lead time, so therefore they're trying to set policies in the electronic conveyancing world and have potentially different policies in the paper world. Because we do have lead time in South Australia, I'm proposing we have one set of policies that's universal across both mediums. The reasons for that obviously are fairly self-explanatory, but it allows for a smooth transition and there's efficiencies between the two systems from a practitioner's point of view. If you set out with every endeavour to do your dealing in the electronic conveyancing world and for whatever reason it can't be finalised in the automated electronic space and you have to bring it out to paper, if there's a misalignment between the policies, there'll be additional work. And therefore that becomes inefficient, it becomes cumbersome, it becomes a challenge for you when you're trying to engage with your consumer or your customer to explain why those policies are different. So I don't see there's any reason for us not to strongly strive to align the policies across both mediums. It obviously avoids complexity with the two separate systems. If you're lodging in paper and electronic, you can engage with your clients one set of policies and then you can make a choice about which medium you want to use in relation to the lodgement or the settlement of those two of your documents. It also removes obviously barriers to entry. Any difference with something new, some change program, if you make it easy to do one against the other, it creates a barrier to entry. People are more comfortable in the paper space. They may gravitate more towards the paper space. And it's important from us as a state to be competitive and to remain competitive, that we get on board and we get active as quick as possibly can in the electronic conveyancing space. One of the things it does do is it removes the state borders. So electronic conveyancing is going to be run on a national perspective. What it does for us in South Australia, it makes us a more competitive marketplace with those borders removed. Bigger lawyer firms, conveyancing firms on the eastern seaboard could choose to expand their business model, could choose to expand into South Australia. So from that perspective, it's important that we remain competitive and we're ahead of the game. And I believe if we can align these policies, we will definitely be ahead of the game and will be advantageous when we do roll out electronic conveyancing. Obviously, with any reform, there's major legislative amendments, and those amendments are required for the majority of the policy changes I'm going to go through in an overview today. Electronic conveyancing will be the driver of those reforms. But anywhere where we can adopt policies in the current environment, we will be striving to do that. We'll be trying to actively engage on a change management program that's rolling, and it's rolling as we move towards electronic conveyancing. One thing I don't think would be beneficial to any of us if we all of a sudden introduce an electronic conveyancing system and another 5 brand new policies that you need to get used to all in the one as a big bang approach. So we're here today to release the first one, which Cristina will go through in detail, and I'll give you an overview of the other 3 major pillars of policy change that you'll see in the marketplace in South Australia. Steve mentioned we've got to introduce a national law. We also need to make reforms to the Real Property Act. Still talks about dupe titles, still talks about wet signatures. It's fairly outdated. We're using the opportunity to modernise it and obviously make it applicable that we can introduce electronic conveyancing into the state. I was quoted in an article not long ago to saying that it's the biggest change to the Torrens titling system ever in 150 years. And I don't think that's far from the truth when we go through some of these reforms. So it's important that we have a strong consultation plan and we engage with industry. As I mentioned in the intro, this will be the first of many of these sessions as we roll out policies and we gain your input into various policy positions that we may take on a number of the reforms that need to be had. So we've created an industry reference group that has members from the AIC, the Law Society, has seconded conveyancers, and it has financial institution representation as well. So if you like, they're the initial sounding board. I come up with a policy position, the uniform, take for example, the no policy change between paper and electronic. We run it across this stakeholder group. They tell me whether it's a good or bad idea or it might need tinkering, and then we go away, make a decision, and then we'll roll out the broader policy to the broader industry. So we've created this group as the initial sounding board. We'll have industry information sessions like we're having today. We also will be recording, so if people can't attend these sessions, or if people want to go back and remember what has been said, or may want to review what's been said, these video recordings will be available through our website, and obviously for people in the regional areas as well that may find it more difficult to attend, but they'll be loaded on our website extremely short, or shortly thereafter of these sessions being held. There'll be publication of updates and policy papers on our website. Cristina will release the verification of identity policy today. That is available on our website, and again I do encourage you to go in, have a look and provide your feedback. And obviously we're moving into the social media world. We've actually generated a Twitter account, and in the next few weeks we should be active in that space where we'll be tweeting out various things about what might be happening in land services to keep you abreast of the various changes locally but also nationally. So we are very much committed to keeping you engaged and informed and hearing your views, and then we'll release and finalise some of the policies and some of the directions for South Australia. The major policy changes that you will see: verification of identity, client authorisation, priority notices, and the removal of the dupe titles. Now I hope these have all touched you in some way or another at some point and they're not foreign to you. I guess the removal of the dupe titles is probably one that does stand out. The others may be a little foreign. That's the challenge that we face in consultating with you to get these policy changes across to allow us to proactively implement electronic conveyancing. So today I'll go through them broadly. As I said, there'll be follow-up sessions where we're closer to releasing the policies that will re-engage with you and have these sessions, and obviously today we're introducing the client authorisation. So the verification of identity, Christina's going to go through in explicit detail, but from my perspective it's the first building block that we release as we move towards electronic conveyancing. There's a need for you to identify your client in a face-to-face environment and or use an agent. So from every client you will need to prove, or you need to have proof that you have identified them to the satisfactory of the policy, which again Cristina will go through. It's also the foundation for client authorisations. So what client authorisations are is effectively your client giving you the authority to act on their behalf for a transaction. So where this is going through the client authorisation is essentially removing signatures off documents. You will sign on your client's behalf, whether it be electronically through the use of a digital signature or through a wet signature on a transfer document, for instance. So the certifying parties, or the two certifying parties, a transfer or transferee's representatives, will be the signatures on that document. Underpinning that is a client authorisation, and that's subject to future policy release. And obviously I think if we can get maturity in the verification of identity, where you identify your clients in a face-to-face environment, you have explicit instructions to act on their behalf, it allows for us to eventually remove the dupe title. So there is no doubt that we're moving towards a system that does not support a duplicate certificate of title. And so there's some of the things that we're doing. The second one, the client authorisation, I touched on. It's closely linked to the VOI, where you need to represent or identify your client. It removes the signatures off documents, as I've said. That also simplifies the witnessing requirements. We no longer need to see witnessing. Your signature's on there. That's making representation that you do have the authority and you also have identified your client. The client will sign the form, obviously giving you the explicit authority to act on their behalf. And as I mentioned, the conveyancer or practitioner will certify the document. That certification will be codified in legislation to say that you do have a client authorisation from your client and you have undertaken the verification of identity to the standard released in the policy. The client authorisation, again, that's just a broad overview. That will be subject to consultation as we move further forward. As we've experienced internally in the project, the devil's in the detail, as you can expect. So the more we discuss about these things, the more things float to the top, and we're continually revising and revisiting our policy positions. Priority notices. They exist in Tasmania and Queensland. And effectively what they allow is you to put a flag against the register notifying anyone who may search that particular title that there's a transaction pending. So if you like, it preserves priority for dealings for which you're a party to. It gives confidence for those transactions. If we're working in a medium where we have paper documents and electronic documents, and people may choose to work in either, a priority notice will be up against the register, allowing people to know that there's a settlement about to happen on this particular property. So it lets the market know there's a contract sold and there's documents pending that are going to fulfil the obligations on that contract. Again, that's another, we're working through it. We expect it to have a period of about 90 days where it will preserve your priority. It will allow it to be extended once, and there needs to be suitable detail in the priority notices so anyone searching the register can have a conversation with another practitioner if there's an issue around equities or other things like that. So that's again another product and a new product into South Australia that's closely linked as we move towards electronic conveyancing. We believe once we get maturity in the lodgement of priority notices, in Tasmania about 98% of settlements have priority notices lodged. It's not expected to be made mandatory at this point in South Australia, but we believe we get maturity in that market, that closely supports the removal of the dupe title. So if you can flag the register, that gives you some certainty that you preserve your priority. It lets everyone else know who's searching the register that someone has a transaction pending. I don't believe we need a dupe title anymore. And obviously it's an added security measure in case we do get someone that wants to be untoward and they want to have multiple settlements on one property. If you've got a priority notice there for 90 days, you're made aware if another contract lands on your desk that there's a competing equities issue and you have a conversation. And so it's a security measure as well around fraud and an added strength to that. I've touched on those three policies. I think once we get to a position of maturity in the market, that does allow us and it affords us the ability to be able to remove the dupe title. The dupe title doesn't work as you'd all expect in an electronic environment, and so I believe let's remove it totally. Other states, again, because they don't necessarily have the lead time, they're bringing in dual policies where they'll remove the dupe title in the electronic world but keep the dupe title if they can in the paper world, acknowledging that with national consistency everyone is moving towards the removal of the dupe title. As I said, I think it's probably some time away. We do need to get those policies embedded. We need to get the market confident in the use of those policies. We need to get strength in those policies. But when we do get there, I think the dupe title can be removed. Obviously, there's good reason for that. It does reduce costs for us. It reduces costs for the industry, reduce production costs, etc. And it makes it easier to deal with property. So for me, there's some real major blocks that we need to work through in the next 12 to 18 months. And the first one's the legal framework. As I said, those documents are available on the NEC website, and if you want to go through Land Services, the link will take you through. The first thing we're releasing today is the verification of identity policy. Cristina will go through that in some detail, and that's the first step. We believe, well, we can do that under the current regime of legislation, and so that's the first step as we move forward towards electronic conveyancing. The other three policies all require some legislative change from an enforcement point of view and a codification point of view, and so client authorisation will be the next one, which will, as I mentioned, allow you to act and sign on behalf of your client. Priority notices will allow you to flag the register that there's transactions pending, and it will outline what those transactions are and who the parties are to those transactions. That then allows us to remove the dreaded duplicate title. And then we've finished our reforms that we need to do to get you working in the electronic conveyancing space. These are significant reforms. I've glossed over them in about 10 minutes, and every time we meet to discuss one of the policy ones, the priority notice one we've been discussing the last 2 weeks, and every time we meet we take an hour and a half and we still then uncover something else. So these are very significant reforms that are going to take a large amount of time and consultation to get them implemented in a fit state that can work and improve the market in South Australia. Some of the time frames. I'll skip the page. The VOI we released today, intentions to implement it from the 1st to the 7th this year, with a 3-month lead time for practitioners to get across and aware of it, and there's training that needs to obviously happen with that, and we'll give you an opportunity to give your feedback, and Cristina will give you the dates for that. The 4th quarter 2014, there's significant legislative reform that needs to happen, both from a conveyancing law, national law, and also the Real Property Act. Our target is to have that finished by the end of 2014. As I mentioned, those other policies need to have some legislative backing. So quickly or shortly thereafter, we'll be out with the client authorisation form. It doesn't mean we won't be consulting and engaging with you before then. We would like to think that we have that finalised, the consultation done, the form bedded down, industry trained, and so when we have the legislative power to enforce it, we'll roll it out and implement it straight away. I don't intend to start consulting once we have the legislative power to do so. First quarter 15, our new system comes in, so the sailor system will be implemented in the first quarter 2015. That will have in it the functionality for priority notices, so it's a matter of the education, training and policy around priority notices, and then that functionality can be implemented. The removal of dupe titles 15, and then electronic conveyancing we see implementing it shortly thereafter into South Australia. So, you know, by June 2015, we will be in a position to implement it in South Australia, subject to it being satisfactorily received, obviously, in other jurisdictions and it being a success. Our rollout strategy, I guess, is fairly flexible at this stage. It'll be really dependent on the learnings of the other state about whether we go discharge mortgage or whether we go the whole settlement process. It will very much be guided by what happens in the experience of the other states as we move towards that. But we've got a lot of policy change and a lot of change that needs to go through before we get to the IT systems, and it's about readying you as best we possibly can to make sure we're prepared as a market when we do implement it. Questions?
Client wants their title, like they pay cash for a property, do they get a title then? Or?
No. The short answer is no.
Yeah.
What we'll probably do, we will introduce some sort of product that you can purchase, or when it's registered, you'll get something back to show that it's registered. It just won't have a legal standing as a dupe title, so it'll be something that you might be able to use to market and provide to your client that will give them the evidence that they want, but also give you an opportunity to market your firm.
And what about insurance? Is like all of this going to affect insurance and things like that?
The documents that Steve talked about in the MOR, the MPR, it's fair to say one of the challenges ARNEX faced and the state project team is the vested interests of the various groups, and the insurers have been one of those groups that have been consulted. So those documents, as they were being formed, have been consulted extensively with the Australian Bankers Association, the insurers, the Law Council, the Law Societies, the AICs, and so trying to pull together all the various interests has been a challenge, but the insurers have definitely been at the table and have been engaged through this whole process. No further questions? The first session, priority notices seem to generate a fair bit of discussion at the first session.
With the removal of the duplicate title, will there be like a transition of old titles coming in and then no more coming out? Will we have to?
That's not my intention.
So everyone who's got a title now that does a transaction, once it's come in, they just hang on to that. It's worthless.
That's my intention, but that'll be subject to discussion. I understand there may be some benefit in bringing it back, but there'd be significant cost in returning all those dupe titles back into the Lands Titles Office, both to you and to us. So my intention is to render them from a certain date void. Yep.
Will the Real Property Acts be aligned?
There is a driving force out there to align the Real Property Act. There's a draft National Torrens Title Act that's currently being circulated to all Attorney Generals, being driven primarily by the Law Council. And so that is taking shape, and there are conversations happening. It's fair to say, will it happen in accord with electronic conveyancing? Probably not. Probably not.
So the driver of that's New South Wales, I assume?
The Law Council, I think the primary driver's Peter Butt, and so I think he does reside in New South Wales. Yeah, so it's a Property Reform Law Alliance, Property Law Reform Alliance. They're driving it, and they have been driving it fairly heavily. So they're into the attorneys at the moment with their draft bill.
Whilst we have the South Australian Real Property Act, whatever we can do in paper, we can do electronically once the system's in.
Yeah. There'll be limitations through electronic conveyancing. There's not the expectation that electronic conveyancing will cater for all document types. So at the moment, the first release is discharge mortgage. Second release is discharge mortgage, transfer, caveat and withdrawal of caveat. Yep. And priority notices. And that's where it stopped as in relation to the extent around electronic conveyancing at this stage. So your leases, your court orders, your more complicated documents will still need to be lodged through the paper channel.
Is this going to be a problem for us then, as conveyancers, when conveyancers aren't recognised in any other state?
There will be challenges in the states where conveyancers aren't recognised. Yeah. There will.
Just a question in respect to the fact that you'll have a choice of whether you do electronic conveyancing or still continue in the paper format.
Yeah.
How's that going to work between conveyancers? Will there, what if everyone chooses to stay?
In paper?
Yes, so
yeah.
Will there be some criteria there?
I can influence government policy around the pricing, but I won't have the final say, and I'd like to think there'd probably be some price differential between the electronic and paper world. That said, the banks have invested in electronic conveyancing, so there's an expectation that the banks may drag along the practitioners into the electronic conveyancing space because of the efficiencies to their business model, and so we'll have to wait and see how that unfolds.
Because if someone chooses to go down the paper trail, does that mean the banks still have to meet at the Lands Titles Office to finalise that transaction?
More than likely, that's right. And you can't have a settlement that's half paper, half electronic. So it's really about the banks and the practitioners coming together and saying, can this suite of documents be done in the electronic world? Do we want to do it in the electronic world? And then there's that collaboration beforehand, then it gets kicked off in the electronic world. That's right.
In this situation where you've got an intended dealing, say in order of court,
Yep.
or the situation that you and I know of where there's a satisfaction of an order of court, is there, with the notification system that we're going to implement, a way that even though that drags it out of the electronic world, that we're able to give an electronic notification that there's a transaction which might be a competing equity to what's happening at the time electronically. So say, for example, you've got Mara and Park Hill have sold the property, but there's an order against Mark Hettle's interest, and you're a solicitor or a conveyancer acting on behalf of a solicitor that's come in to register an order of court or a satisfaction of an order of court. That's therefore going to drag it out of, I understand, out of the electronic platform. And how are you going to liaise with banks that are going to insist on an electronic platform when you've got other documents that need to be dealt with within the frame?
You won't be able to insist. If there's a discharge of a court order, for instance, and electronic conveyancing doesn't cater for a discharge of that court order, there's only one way you can do it, and that's through paper. Doesn't mean that you can't come to some arrangement with the other practitioners and say, look, I'll lodge the discharge of court order, get it noted on the system, and then the rest of the settlement can happen electronically, or you just lodge it all in the paper-based system. What you will have, though, in that case, is you will have a priority notice on the title that will be lodged electronically, that will tell the market that there's a settlement pending, but you'll also have a court order on the title as well, and that will need to be considered. You still have a choice of what you want to do, but the priority notice I would expect would get lodged once the once the contract lands on your desk. I would expect priority notices to be lodged, within a short period of time, and then that preserves your priority for, at this stage, we're thinking 90 days.
Brenton, do you expect that possibly clients will be influenced by banks to participate in the electronic environment?
I think there's two things. I think clients will definitely be influenced by banks to participate. And I also think that there'll be market forces at play where there'll be people that may be a bit more proactive than others in the business world, and they may see it as an opportunity. And so that'll drive a change in the market as well. So all we're trying to do in South Australia is give you the best information we can and prepare you the best we possibly can, understanding that, as I mentioned earlier, those state borders are taken down with this model. And so we just need to make sure we're ahead of the game. But people still have a choice, obviously, but I think the market, both the banks and the market itself, will evolve.
When you say the borders are being taken down, are you saying a legal practitioner admitted in the state of New South Wales
Yep.
can sign off on a transfer in the state of
Yep.
South Australia?
Yes. Now, the reciprocal issue around conveyances obviously doesn't exist in Queensland. Queensland don't have conveyances, which is an interesting point of discussion amongst the registrars, but yeah, they do. So that's what I mean. There's going to, it does, the dynamics of the market as we know it today is going to change. How broadly, well, I guess that's up to people to make that judgment, but it will definitely shift.
How will that work if you've got, like the gentleman said, a solicitor in New South Wales, and the other party who's acting for the other side chooses to go into keeping it still in the paper world? How will they be able to settle that?
Can't. Well, you would have to have that conversation beforehand, because you can't have a mixed series through both mediums. They have to be, the series will need to be lodged either paper or electronic, so it'll be a conversation you have to have with the other practitioner.
And the priority notice, is that a caveat?
No. Preserves your priority. We're very careful around the caveating effect, so it's preserving your priority for 90 days. It doesn't preserve it in the face of your priority type documents, so your caveats, your court orders and things like that. But it will preserve it against other settlements, if you like, acknowledging that you can, if you do have a priority notice and you wish for something to be registered, you can consent to that being registered prior to your dealing.
Well, just hang on with this. Who's going to be prioritising all the orders? Like, is that going to be a state-based thing? Is it going to be national? Like...
Well, ARNEC is an oversight, is a regulator from a national perspective, and so ARNEC is giving the LNOs the approval to exist, and so they need to satisfy ARNEC in the first instance. But it's fair to say that that doesn't gazum any state-based legislation around approval. So in South Australia, the final approval is with me, albeit acknowledging that ARNEC has a role to play, and I sit on ARNEC, and we're committed to one set of guidelines and one set of rules. So if ARNEC's satisfied as a collective group, I wouldn't be saying they can't establish themselves in South Australia. But it does sit, because of the way the legislation is around Australia, the final tick, if you like, is with the registrar. The national law doesn't fetter any local registrar's powers.
So there could be different guidelines binding me as a practitioner in the state of South Australia, or indeed if I'm doing work in the state of New South Wales?
The short answer is yes. I guess Steve mentioned, with ARNEC, there is a commitment that we limit that as much as we possibly can, if not avoid it totally. But there can be differences, but we are committed to trying to limit those differences as much as we possibly can. And I know from my perspective, our starting position is always how can we make it consistent. Now, I can't speak on behalf of other registrars around the country, but we will try to shift if we possibly can to make it consistent, as long as it doesn't introduce our market and to risks or increase risk.
Priority notices. If someone puts a priority notice on, who takes it off?
Person who puts it on. Or the documents are lodged that match with the priority notice, or the registrar.
Okay. At what stage would the priority notice go on?
That's for the market to determine. We've allowed it to have its effect for 90 days. So we're saying, well, we would think if the contract lobs, you've determined the composition of the series of documents, the priority notice is put on. Okay. And then it goes.
What concerns me is if you think you have to get a contract, you go ahead and put a priority notice on, that falls through, and those people don't take that notice off, you come along with another transaction.
Yep.
So that means we would have to get approval from the first person to take that off?
You can either...
Otherwise, got to wait 90 days.
Yeah, you can withdraw it, it'll expire, or you can apply to the registrar to have it cancelled.
You can actually apply to the registrar.
Yeah.
Thank you.
Will the banks be able to act on behalf of purchasers or vendors?
They need to fit the rules of the MPR, which is a subscriber, so conveyancers or lawyers.
Sorry, can you repeat that?
Well, if they're going to certify it correct, they still need to be certified correct in accord with the law, and the law still says it's conveyancer, solicitor, or the applicant themselves. So they can participate in electronic conveyancing, but certifying documents for the purpose of the Real Property Act, there's been no shift in that. So if the banks wanted to employ, I guess, a conveyancer or a solicitor and extend their business model, that's up for them to determine whether that's good business.
But their right to participate will be no different to their right to participate.
That's right.
In which case they can't.
They can't certify documents correct unless they have solicitors, conveyancers.
And they receive income as a conveyancer.
Or that might be for the Office of the Consumer Business Services, I'm not sure. I'm not sure.
With the legislative amendment, is that going to include other associated acts, such as the Legal Practitioners Act?
Yep. Yeah, and there's a suite of them. I don't know what was the last count for 170. 170 acts make reference to various pieces, particularly the dupe title, of course. So there's about 170 that we do need to change to align with this initiative. Any other questions, comments before I hand over Cristina to release the first policy in some detail? No? Thank you.
So the first policy, the verification of identity policy, I'm just going to be talking through the detail today. So reasons for introduction. The first thing is that it is included in those documents that Brenton talked about, model participation rules for the electronic conveyancing. And as such, all jurisdictions will also be looking at introducing it into their paper world. However, the timing of when jurisdictions introduce it may vary between states. The introduction of this policy is part of South Australia's strategy about aligning the paper and electronic environments in order to have one set of policies no matter which medium, and to avoid the complexity of dealing with two separate systems. So this first policy will provide the foundations necessary to allow the proposed business changes, which Brenton discussed, to be implemented, and it'll also strengthen the land administration system, as it'll improve the accuracy of the information that is entered onto our register. So I'm just going to run through the next few slides the key provisions of the verification of identity policy, these being requirements for the persons to be identified, the requirement to take reasonable steps to verify the identity of the person required, process outlined in the policy which will be taken to constitute reasonable steps, identification document categories to be used if following the process, specific requirements detailed in the policy, the use of agents and self-represented parties. So, the persons required to be identified under the policy parallel with the requirements in the model participation rules for electronic conveyancing. A representative, which we've defined in our policy as a conveyancer or a legal practitioner who acts on behalf of a party to a conveyancing transaction, they need to verify the identity of any of their clients or any attorney or individual acting on behalf of that client. An authorised deposit-taking institute, or their representative if they have one, must identify the mortgagor if the mortgagor does not have a representative. The identity of any other person being given a duplicate certificate of title, which is not a representative or authorised deposit-taking institute for the transaction, must also be verified. And any person providing an identifier declaration also needs to have their identity verified. An identifier declaration is required when the person to be identified is using a limited category of identification documents. The requirement in the policy is that the representative or the authorised deposit-taking institute takes reasonable steps to verify the identity of the person required to be identified. If the representative or authorised deposit-taking institute follows the process outlined in the policy, then this will be considered that reasonable steps have been taken. Okay, so if the representative or authorised deposit-taking institute uses the process outlined in the policy, verification of identity should occur at a face-to-face interview with the person being identified. Representative, authorised deposit-taking institute, or their agent must be satisfied that the person being identified is a reasonable likeness to the person depicted in the identification photographs. As with the model participation rules, the verification of identity does not need to occur if there's a face-to-face interview with the person required to be identified and their identity has been verified in the previous 24 months in accordance with this policy. Process outlined in the policy requires original and current documents to be produced from a table of categories listed in the policy. The representative or authorised deposit-taking institute will need to make a statement on the respective real property document that they have taken reasonable steps to verify the identity of the transacting party. The statement required is outlined in the policy, and the particulars around the practicalities of how this is to be contained on our panel forms will be the subject of a notice to lodging parties. Any supporting verification of identity material must be retained for 7 years, and that's to keep it consistent with what's required in the model participation rules. Now, this is the table that you'll find listed in the policy with the document categories, and this is what would be used if they used the process in the policy. So the person undertaking the verification of identity must be satisfied that a prior category of documents in the table cannot be satisfied before using a subsequent category. As most of the documents listed in the policy are common identification documents, I just wanted to run through some of the more unique requirements. So one of those being Category 4, which is a limited category of identification, we require an identifier declaration. The identifier declaration is satisfied by the declarant providing a statutory declaration to support the identification of the person being identified. The representative, authorised deposit-taking institute, or their agent would also need to verify the identity of the declarant, which provides that declaration. And they should undertake reasonable inquiries to satisfy themselves that the declarant is an adult, has known the person being identified for more than 12 months, is not a relative, and is not a party to the transaction. Now, if they use Category 4B, which is where a full birth, citizenship or descent certificate cannot be produced, the declarant must also be someone that is a bank manager or a community leader, court officer, doctor, land council office holder, local government office holder, nurse, public servant, police officer, legal practitioner or a licensed conveyancer. And Category 5 is for persons that are not Australian citizens or residents. So the policy outlines specific requirements for verification of identity processes in relation to body corporates, attorneys, and identification that takes place in a foreign country. So for a body corporate, the existence and identity of the body corporate should be confirmed by conducting a search of the records of the Australian Securities Investment Commission or any other regulatory body they're required to be registered with. Reasonable steps should be taken to establish who's authorised to sign or witness the affixing of the seal on behalf of the body corporate. And then that person or persons' identity should be verified. For an attorney, the details of the attorney and the donor should be confirmed from the registered power of attorney. Reasonable steps should be taken to establish that the conveyancing transaction is authorised by the power of attorney, and the identity of the attorney should be verified. Verification of identity undertaken in a foreign country is to be conducted by an Australian consular officer or an Australian diplomatic officer. Where the person being identified is a member of the Australian Defence Force, it can be a competent officer. Now, if the representative or authorised deposit-taking institute wishes to engage an agent to undertake the verification of identity on their behalf, they should engage an agent that they reasonably believe is reputable, competent, and who either has professional indemnity and fidelity insurance for an amount of at least 1.5 million per claim, or is a solicitor or conveyancer, or is an authorised deposit-taking institute. If using the process under the policy, Evidence that the representative is required to receive from the agent is a certification about how the identification was done and that they followed the process. Copies of documents signed, dated and endorsed as a true copy of the original documents produced to verify that person's identity. Now, just on a side note about who can be agents, Western Australia has introduced a verification of identity policy, which you may be aware of. And as a result, they have some commercial arrangements with Australia Post in place to act as agents. Our understanding is that Australia Post would also be willing to supply this service in South Australia. And key industry bodies are aware that Australia Post are able to provide this service, and some of these bodies are arranging sessions with Australia Post to have information sessions with the representatives. So, next one. Okay, so self-represented parties. In the limited circumstances where a transacting party that you're dealing with is unrepresented at settlement and there's no authorised deposit taking institute as part of the transaction, you would expect that an unrepresented party has followed the verification of identity process as outlined in the policy and includes the necessary documents with the real property document. So self-represented parties need to be identified by an authorised person, which under the policy allows for justices of peace, proclaimed officers, solicitors, conveyancers and public notaries. And they're also required to lodge with the real property documents that authorised person's certification in relation to the verification of identity process and copies of documents signed, dated and endorsed as a true copy of the original documents produced. Now that documentation won't become part of the register. It's for the Lands Titles Office staff to ensure that the self-represented person's identity has been satisfactorily verified, so that we're also taking the same precautions as we're requiring of industry. So the introduction date of the policy, as Brenton mentioned, is going to be third quarter of this year, targeting a date of 1st July 13. It's intended to have 3-month lead time before full compliance is required with the policy, giving businesses an opportunity to transition. Policy has been published on our webpage, and we do welcome feedback and comments on the policy. We do request that feedback is sent through by the end of May. And once the policy and the video recordings of these sessions are published, we will be releasing a notice to lodging parties just to notify everyone of their release. And questions?
Excuse me, if you ask for a client on a regular basis, would you only have to get their identity verified for the first time?
Yeah, so it's
every transaction.
What you're going to have to do is put a statement on the document that you've taken reasonable steps to verify their identity. So if you see them all the time, reasonable steps may be that you've just done it the first time or whatever. In the actual policy, there's a 24-month gap. So if you want to rely on the safe harbour provisions of the policy, then you would use that 24 months, and then in the next 24 months you'd identify them again. But it is what you think is reasonable. So you could not go with the 24 months, and if it's reasonable in the circumstances because you always deal with them, then that's...
Sorry, can you clarify that? So if I've got a 35-year relationship with somebody, are you saying that I have to re-identify them every 2 years? Even I've known them for 35 years.
If it's, all you have to do is make a statement that you've taken reasonable steps to verify their identity. So in your case that you've just outlined, one would think that possibly reasonable steps would be not to identify them every 2 years, but the policy to set a standard, which we say is that's what we constitute reasonable steps, it gives 2 years. So if you've identified them in the previous 24 months and you have a face-to-face in-person interview with them, you don't have to go through the whole process again. But that's sort of what we've outlined as what we constitute reasonable steps. That's not to say that if you don't follow that, it's not reasonable steps, but it'll be dependent on the circumstances.
Certainly now there are only selected Australia Post officers that can, for example, take a passport application.
My last conversation with them was that the majority of them are, and I know Glenys has been in contact with Australia Post. She may be better positioned to answer that, but my understanding is the majority of, if not all of them, have already had the training across the country. And so their intention is obviously to strengthen that training here now that we've released that policy and undertake the required training. But I don't know, Glenys, you got any further things you may wish to add?
Yeah. We're talking with them at the moment, and what we're planning to do is possibly in the 3 months prior to the compulsory completion of it. We'll be running a series of workshops with the land services to give more details, a small introductory of exactly what's going to be happening, and then we'll be inviting Australia Post to actually give you a demonstration of how we go about doing it with them, what the process is. I believe it will all be done electronically. You won't have to go to your office to go to the post office to follow that up. That will be done electronically. You will log into their system, and the identification process will just come direct to you electronically. So, but you will have some information and training on how that will all work, and I'm sure they'll have statistics on exactly how many of their post offices will do it at that time. But we'll try and get the information to you. We'll certainly be working. We're looking at possibly June, July, August to do a series of information sessions and training and all that.
If I have a fraudulent person come into my office and produce false identification, which appears to be genuine, am I not at greater risk now than I am currently? Or have I taken reasonable steps by acting on the fraudulent document?
Well, that'd be a matter for the court, but I would have thought if you, on face value, if that evidence looks to be valid and you've relied on that evidence and there's not factors that may deem it not to be reasonable, you'll move into safe harbour. So if someone does produce this beautiful counterfeit licence or whatever, you relied, the intention is not to say, well, you relied on it, it's yours. The assurance fund still exists, there's no change of liability. So as long as it's reasonable and you've relied on it, you move to safe harbour and the assurance fund will pick up any of those circumstances that may fit where it's deemed reasonable. So the liability today, well, I'd say the liability is still the same, it's just we're codifying the requirements around identification.
Can I just add to that, Brenton? The PI insurance this year, sorry, can you hear that now? The insurance this year will be increased to the minimum requirement of the 1.5 million.
Yeah. So at the moment, the Australia Post are in the market from an agent, but there's nothing to stop another solicitor or another conveyancer undertaking the VOI on your behalf, given the 1.5 insurance criteria, and they meet all those criteria. If they wish to do that, or you wish to enter into a partnership with someone that's geographically located differently in a different position to you, you know, so be it. So we haven't been prescriptive. We've just said an agent, they meet these criteria, they can be an agent, they follow this policy, the reasonable steps, you move to safe harbour. Any further questions, comments?
What about regard to the real estate agents? Do they have any duty to identify their clients when they're selling them? That
was raised because in Western Australia they have extended the obligation outward further to real estate agents. Unfortunately, in South Australia, I don't have any sort of control or regulatory power over the real estate agents. But you'd like to think that they do take some of this on board and they do look at improving their processes or potentially doing some of this identification right up front. But in relation to extending the policy, it doesn't have a role against real estate agents at this stage. Nothing further? I do encourage you to go to our website. The policy is already loaded. So you can have a look at the policy, download it, and by all means I encourage you to flick any feedback back to the email address.
Will the slideshow be on the website as well?
Yes, yeah. So the slideshow will be on the website, the policy is already on the website. We're videoing our information session tomorrow as well, then we'll edit the video and that should be up in the next few weeks as well. So all the information will be available on the website As I said, I encourage you to get up, become familiar with some of the policy changes, some of the challenges we're going to have to work together as we drive forward towards electronic conveyancing. If you have any questions or whatever, by all means flick them through, and I encourage you to do so. The more we talk about it and the more we can advance, the better off we'll all be when the time comes to rolling out the electronic system.